All right, so welcome everyone to today's Willpower Wednesday. We're January the 25th of 2023. Can't believe we made it through 2022. I'm your host for today's episode of Willpower Wednesdays. My name is Tim Phelan. I'm an associate at Cambridge LLP, where I do a fair bit of estate litigation. Joining me for this week's episode is my friend and colleague, Mr. Quinn Giordano. Quinn is also an estates litigator here at Cambridge. And in fact, he and one of our partners, Joe Filiameni, just have been involved in two recent Court of Appeal appearances that deal with this week's topic. Which brings me to announcing this week's topic. As many of you read in our ad for the week, today's topic is under the influence. At what point is strongly suggesting or pressuring a testator to include someone enough to invalidate a will? So, barring the awful pun in this week's title, Quinn, before we get into the substantive part, I just want to remind our audience members that we do have a chat function and we do have a Q&A session at the end of this week's episode. This is usually a very contentious topic and a topic that generally brings up a lot of questions. So we encourage questions from the audience. Those of you in our audience who know Quinn and I well know that us stopping to talk or us stopping talking to answer some questions is a rare occasion. So we're going to do our best to get through the material that we've provided for you today and get to your audience questions. So keep that in mind as we're going through. So Quinn, I guess let's just jump right in. So today's episode, we're going to be talking about a variety of different concepts. We're going to be talking about the capacity. We're going to be talking about undue influence. And we'll also probably touch on what we've labeled as unfortunate situations. So why don't you take a minute to tell our audience about each of these three sort of groupings of situations, and then we'll get into some questions.
Perfect. Well, so we've grouped the discussion into those three categories because very often we do see that they converge. There's on the one hand issues of capacity. There's also issues of undue influence. And then there's a third category, which you pointed out, Tim, those unfortunate situations where it's not quite a capacity issue. It's not quite undue influence. I hear we have a third guest. I think maybe someone's joined the panel.
Tim, yes, I have a dog in the house today, which is unusual. I apologize to members of our audience. I'll try to keep the dog quiet here.
You know, I think it might really spice up this presentation because we are going to deal with some pretty heavy subjects. Yes,
well, depending on the day, sometimes the dog has more intelligent things to say than I do. So
I'd add myself to that category. But those are the basic three categories for our discussion today: the capacity, the undue influence, and the unfortunate situations. The third category is where somebody may not actually be unduly influenced and they may not actually be lacking in capacity, but there may be something very unfortunate about an arrangement that somebody chooses entirely of their own volition, which might be what the court might call an improvident bargain. But the court is always going to respect contracts and agreements that are made between capable parties. So on to that first point, the distinction between capacity and undue influence. This is very much a live issue right now at the Court of Appeal. This is something that came up in the recent Palachuk case, which is one that Cambridge was involved in. The issue there was just that, whether a finding of capacity precludes any further investigation of undue influence. In other words, if somebody has complete capacity to make a will or to make a power of attorney, does the court even need to investigate whether that will or power of attorney was made under undue influence? There's a few underlying principles that the court lays out in starting that analysis. One is that the law is always going to value autonomy and presume capacity unless the contrary is proven. And that's necessary because the burden of having to actually prove one's own capacity could lead to some absurd results. And it would certainly put a lot of unreasonable pressure on us to prove that we have capacity. I mean, just think of if the presumption went the other direction. If you had to presume right now that you have capacity, Tim, where do you even begin with that? It might be quite difficult.
Yeah, well, exactly. I think that's wholly right. I wanted to pause for a minute, remind our audience that you and I have talked about this on a couple of other podcasts that we've done together, or webinars, I suppose, that we've done together. But when you're talking about capacity issues, this week we're talking about what we call testamentary capacity, the capacity to make a will. But when you're talking about capacity, ladies and gentlemen, capacity is really what I would call a task-specific analysis. What that means is that the capacity to complete a task depends on exactly what task you're trying to complete. So the task to make a will is different, or the capacity, sorry, to make a will is different from the capacity to grant a power of attorney. And it's different from the capacity, say, for example, to decide what breakfast cereal you're going to have in the morning. So with that in mind, with that distinction in mind between the various types of capacity, I think we can turn to actually outlining the sort of core principles associated with testamentary capacity. So what exactly is the court looking to, Quinn, when the court is trying to figure out whether somebody has testamentary capacity or not?
Well, there is a test, and I'll jump to that. But before I do, I just want to finish off on this one point, which is that as we are considering capacity to do certain things, as you rightfully pointed out, Tim, it's very important to consider that you still have capacity if you're capable of making these decisions with the assistance of another person. So again, for the very high burden that you might think is involved in capacity, in our regular lives, we rely on all kinds of other people to assist us with things that we do in our jobs, in our daily life. So the court is not looking, for a standard of a 100% individual person who needs no one and does everything on their own. Again, that would be an unreasonable standard. Another thing to keep in mind there is that a single medical diagnosis is not going to be what does it. It won't be simply a matter of whether a person has experienced mental health challenges in their life, health challenges of other kinds, or whether they had cognitive impairment at a particular point in time, or even for an extended period of time, because we're looking for a legal distinction here, not simply one medical diagnosis. So those are the facts that the court is going to be looking at. And to your question about testamentary capacity, so there is a test for this. We can look at the Schwartz and Schwartz Ontario Court of Appeal decision, which is referring to a previous test from a case called Banks and Goodfellow. The testator must be sufficiently clear in his understanding and memory to know on his own and in a general way, first, the nature and extent of his property, and his in this case would refer to any person, even though it's gendered language there. Two, the persons who are natural objects of his bounty. Three, the testamentary provisions he's making. And he must moreover be capable of, four, appreciating these factors in relation to each other. And five, forming an orderly desire as to the disposition of his property. So you would think with a definition like that, that clarifies everything. We couldn't possibly have any other questions. And you would be wrong. Tim, as you can see, there's a lot that's vague there. There's a lot that could be fact specific. And it's going to be the lawyer's job, and whoever the parties are involved in a dispute over something like this, to really deal with those facts. And it's going to come down to the advocacy and the evidence that's available to show whether those criteria have been met. And I know you have experience with this, Tim.
Absolutely, absolutely. So for our audience members who may not be lawyers, let's try to simplify that definition. And I'll do my best to paraphrase you, Quinn, and maybe or to paraphrase Schwartz, I suppose, and maybe you can add in. But in order to have testamentary capacity, you've got to understand what property you own and don't own. You've got to understand who you would be expected to benefit. That's the reasonable objects of your bounty. That's some very old-fashioned language, but you should have in your mind the people that you would ordinarily be expected to benefit. That would be, in particular, your children or grandchildren, perhaps siblings, parents. That's not to say that you have to benefit them, but when you are creating the will, you at least have to acknowledge that, I would ordinarily be expected to benefit my son, but he and I had a falling out 5 years ago, and I'm choosing not to. That's perfectly legitimate, but you've got to have it in your mind that that you would ordinarily be expected to benefit him. And the idea is they want to make sure that you haven't forgotten anybody.
Right.
So you've got to understand what you own, who you would ordinarily be expected to benefit, and you've got to understand the nature and consequences of making a will. You have to understand what that kind of a document does, and more particularly what it does not do. I think that's a fair summary. Quinn, am I missing an important element, or is that really the 30,000 foot?
I think as a general summary, yeah, you're on point there, Tim. The thing to keep in mind, and I know we talked about this in a previous episode, testamentary freedom. You have the freedom to put people in a will as you wish, or not put them in your will as you wish. The key distinction is going to be around whether a person might be a dependent. In other words, if you have a spouse who depends on you, or an infant child who depends on you, to completely exclude somebody in that way could create issues where testamentary freedom would no longer be absolute. So that is one thing to keep in mind. But I think we've touched on it exactly right, Tim.
Perfect. Okay, so we'll move slightly into the area of what we call, as lawyers, we call them inter vivos gifts.
Right.
For those of you at home, those are gifts that people give during their life. Inter vivos is just a fancy Latin expression that lawyers like to use because we, for some reason, seem to still like Latin, even though nobody's spoken it in about 2,000 years.
Wrong stance on Latin today. I didn't see that.
Yes, it's a tough stance on Latin today. As a lifelong Catholic too, I don't know. I'm sort of feeling my neck about that. Okay. But I've had it happen in my practice. I'm sure, Quinn, you probably have as well. And those of you that are lawyers sitting at home, you've probably had this as well, where somebody comes in and says, I ended up giving my son or my daughter a large amount of money to help them with a down payment on their home, and I'd like to factor that into my distribution in my will. So that gift to work for a down payment on a home or a gift for whatever purposes is what we call an inter vivos gift, a gift you make during your lifetime. And sometimes those get challenged, especially when those gifts are made sort of in the weeks, days, months preceding somebody's death. And so my question to you, Quinn, is there a different level of capacity that's required to make a will for an inter vivos gift, or how do they differ?
Well, there's a few factors that would be at play with the scenario you're describing there. One, when you're dealing with giving substantial amounts of money to somebody or giving significant property to somebody, what you're giving would be presumed to be something held in trust before it would be presumed to be a gift. So there's something called the presumption of resulting trust. And this is another issue that is a live issue before the Court of Appeal right now on another matter that Cambridge is involved in, which is that, yeah, when we're dealing with family members and people who are very close to one another, at different stages of your life, you may make quite substantial gifts to somebody. And the question is whether you're giving them property so that they can hold it in trust for your benefit, or whether you're giving it to them outright as a gift. So the presumption of resulting trust plays in there. That'd be the presumption that it would not be a gift. And then on the capacity side, the court does have a more nuanced approach with how it will deal with transfers like that. It's going to depend on what exactly you're giving as a gift. The Palachuk case dealt with this in its analysis. We have the Beanie reference case, 1978, and Ball and Mannon. And quoting from that, the court says, at one extreme, if the subject matter and value of a gift are trivial in relation to the donor's other assets, a low degree of understanding will suffice. But at the other extreme, if its effect is to dispose of the donor's only asset of value and thus for practical purposes preempt the devolution of his estate under his will or his intestacy, then the degree of understanding required is as high as that required for a will, and the donor must understand the claims of all potential donees and the extent of the property to be disposed of. In short, if you're making a huge gift, your house, and that's your main asset, there's going to be a similar standard as the capacity for making a will would be applied to that kind of a transfer. If you're making a small gift, what you have in your pocket right now, or some food, we're not talking about the same standard. But then obviously it's going to be a complicated degree between that. What about a watch that has significant sentimental value or monetary value? What about a vehicle? What about a small property in a large catalog of properties that somebody owns? How does that factor into a gift? Again, it's going to come down to the facts and the evidence at hand, and it's going to come down to the advocacy with those facts.
You're right. I think, most of our viewers probably hear us say this quite often on our show, but it depends.
Yes.
Is the classic lawyer's answer. And the reality is, there's just far too many factors. It's hard to say, to make a definitive answer. So we've talked about capacity for a few minutes. Hopefully the viewers at home have a better understanding. I want to move now to the undue influence and what it means and how it operates. And I understand in the Palachuk case that this was an issue that the court was being asked to decide that essentially once the court determined that the testator had capacity, the argument from the other side was that having capacity precludes any undue influence or precludes a finding of undue influence. And so why don't you take a few minutes to talk to us about that argument and about the argument that we made in response?
Right. So some have taken this approach that capacity acts like a threshold question for an undue influence analysis. It remains to be seen exactly how the Court of Appeal is going to approach that. There is another view, which is to say that there's a basis that no, capacity is not the threshold issue. Undue influence and capacity are separate categories. And one of the justifications for that position is that there's undue influence analysis entirely outside of situations involving wills and trusts or elderly people or any other category. It is a separate issue in equity. The doctrine of undue influence is designed to not simply to protect people from making bad decisions, but to save them from being victimized by other people. And you can be victimized by someone even where you truly believe that you're doing the right thing, but you're acting on incorrect information, or you've been misled through, could be fraud, could be misrepresentation of other kinds, and mistaken belief. And anything that takes place in that nature with the purpose of dominating somebody and preventing them from making a free choice is a form of undue influence. Actual undue influence depends on proof of an intentional misconduct. And there's also presumed undue influence, in contrast, which affects people who have acted in sincere belief of their honesty. Dependency by one person over another can raise these presumptions, and the court has recognized a number of different categories. I can go through some of them. Most recognized categories of undue influence, potential undue influence, would be the relationship between a solicitor and a client, a doctor and a patient, a guardian and their ward, as the court calls it, priest and parishioner. You talked a little bit about your Latin there, Tim, so it would play in there. A rest home operator and a patient, future husband and fiance, parent and infant child. These are all situations in which the bargaining power of the two people involved in the relationship is not necessarily going to be even, and there could be the presumption of undue influence flowing from that.
So we had discussed yesterday, just to give the audience maybe a more concrete example of where this comes into play. I can think of a couple of situations. These ones come to mind, but more particularly in the estates context, where somebody who has capacity to make their own decisions, otherwise, relies on the advice and opinion of somebody else, and that person may not be exercising that position of privilege and that position of power in the best interests of this other person. So we came up with a situation. These kinds of events happen all the time in our practice, where a parent has a company. Parent creates this company from nothing, and the parent's children all sort of take leading managerial roles in the company. And then the parent, of course, retires, and the parent has to choose a successor. Parent chooses a successor, usually the oldest child. Sorry for all you youngest children. I'm looking at you, Quinn. Parent usually chooses the oldest child, and then the oldest child starts whispering in parents' ear, saying, that younger brother of mine, he's been milking this company for decades, and you should really think about cutting him out of your will. And it may be that the parent has capacity, but is no longer in a position to verify that information. They're not in a position to go back and check the financial records or something like that, and so they rely on the alleged honesty, or their belief in the honesty of their eldest child, and to the detriment of the younger child, who probably, or in some cases, didn't take anything they weren't entitled to. So that's an example, folks, of a situation where somebody who would otherwise have capacity might still fall victim to the influence of somebody else. I don't know, Quinn, can you think of something, another example from your practice? Or
just sticking with that example, a good rule of thumb to look at there is, what's the likelihood that this person would have done the thing that they did, whether it's changing their will, changing the structure of a company, something like that? What's the likelihood that they would have done that in the absence of some form of undue influence? And then in looking for that, the court is going to go back to the analysis that we were talking about before, all those different factors and comparisons to those factors. Let's look at the nature of the personal relationship. Was there a blood relationship? What's the age difference between the parties? Are there any capacity issues, or something bordering on capacity issues, something that would make somebody vulnerable to influence? When you have all those factors together, again, to your point, it's going to come down to the facts. But yeah, if the person is very unlikely with all those points in mind to have actually made the change, you may be dealing with undue influence.
So I know watching some of our audience members are estate solicitors. They're people who draft wills for a living. Some are financial advisors who may take instructions from clients who may be dealing with capacity problems or problems of undue influence. Sorry. So what is somebody to do? How can the professionals watching protect themselves and their clients from undue influence? What can we do, practically speaking?
Well, there's a number of things that you can do. In preparing for this presentation, I'll give full credit. LawPro has provided very useful instructions and guidelines for this. There are lots of checklists that professionals can turn to, and that clients should expect from their counsel. First of all, ask probing questions. It's important to know exactly who you're dealing with. Are there any, did you know the nature and extent of this person's assets? Do you know the family dynamic? Are you aware of any previous versions of wills or power of attorneys? What was included in those powers of attorneys versus a new power of attorney? Do you have an explanation for why the person is making the change? If you don't have those things, in the circumstance of litigation over these issues, it's going to be very difficult to explain exactly what was going on, and it'll be very difficult to dispel, the suspicion that there might have been something untoward happening when those agreements were being made. Something else to look for is just basic forms of conflict of interest that can come up. How exactly did this person come into your office to make these changes? What were they told? Is there somebody with them? Is this a private meeting, or is there somebody else doing the talking for them? There are other things that the Law Pro points out. Ensuring consistency in instructions, seeking those instructions as often as possible. Basic errors of law are an issue. Time management is always a factor to keep in mind. Is somebody making a decision today versus 10 years from now or 1 month from now? Assets and relationships can change. It's important to make sure that you're following up there. And then as well, conflict of interest, making sure that the person who's speaking to you is making that decision independently from your interest.
I know, practically speaking, when I draft a will for somebody, I always have at least one meeting. I mean, I know it's common. A lot of, I mean, my own grandmother did this when she made her will. A lot of people want their children present if their children are beneficiaries. They'd like to have their children see them witness their formal sense, but they want their children to be part of the will drafting process. Sometimes parents are reliant on children to drive them to the lawyer's appointment and that sort of thing. So it's not uncommon for us to see people come in with somebody else when they want to make a will. But one thing I always try to do is have at least one meeting with that person, with the testator or the soon-to-be testator, solo, one-on-one. It's fine if their companion wants to wait in the waiting room, but I always try to have at least a brief discussion with the testator solo to try to eliminate or at least to try to help address some of these potential concerns. I'm sure some of our other estate solicitors at Cambridge LLP have probably done other episodes on this subject, and they've probably also got some helpful insights. So members of our audience can look out for those as well. I'm cognizant we're almost out of time for this week. I see here that Law Pro also has what we call 6 common causes of problems in making wills. So Quinn, why don't you quickly, while we've got a few minutes, walk our audience members through those 6 common problems, and I'll have a look at our questions from the audience.
Yeah, so those 6 common problems are some of the points that we've discussed already. The first being inadequate investigation, failing to ask about what assets are, not asking about the existing of prior wills or prior power of attorneys, not getting into details about marital status, children, stepchildren, whether a spouse is a married spouse or common law. Details like that are going to matter. Second is communication, making sure that the will is consistent with the instructions that you've received and making sure that you're able to follow up on that. Errors of law, we touched on that briefly. Not knowing key provisions of the Income Tax Act or other applicable legislation is important. Time management, missing a deadline for an election under the Family Law Act, for instance, is another common error. And then the other 2 are just clerical errors, which you would expect, and conflicts of interest, which we've touched on. And to your point there before we move on, Tim, if you are dealing with somebody in that one-on-one situation and you suspect that maybe you're not getting proper instructions because they could be impaired, again, this is where a professional capacity assessor is going to be useful. And it's always important to keep that in mind and use a capacity assessor if you think that you may be dealing with somebody who doesn't have capacity.
Very good. I forgot to mention at the beginning, members of our audience, but our questions are anonymous. So when we get them, I don't always, and I won't read out the name of the person who's asking. So if you're not asking a question because you're worried about being singled out, please don't. But our first question comes from an audience member, and essentially the audience member is saying that their brother goes in to see their mother who's in a nursing home every day. And this nursing home, because of COVID, has had a regulation in place that only one visitor is allowed into the nursing home at any given time. and they're concerned that the sibling has been whispering in their mother's ear because they say that mom used to call them every day, and now mom doesn't call them, and there is a problem. They tried to call, and they're now being told that there's some kind of an order or a direction preventing them from actually getting through to their mother. So what is an audience member like that to do in a situation like that?
Well, these are the kinds of tragic situations that fall into the unfortunate category, the third category we're talking about. That could very well be a capacity issue or an undue influence issue. I don't want to comment on a particular case. We need to know the facts. It's all going to be fact specific. So we need to know, is there something being told to this person that is untrue, that they're being misled in some way? Are they lacking capacity in some way that they're not able to really understand what's being told to them? The facts are going to be specific, and we would have to look at that and determine whether anything has happened. The other thing is, has this person actually acted on that information and done anything yet to change their will or to change their arrangements? May not be the case. Keep in mind, with testamentary freedom, if you do not like a family member for whatever reason, and you decide that you don't want to give them a large portion of your estate, you have the freedom to do that. But if you're actively being misled, and if somebody is taking advantage of a special relationship, you're going to need facts to establish that. And if you can show that that is happening, yes, then there may very well be undue influence. But meeting with an elderly person in a care home, that in itself is not undue influence, but it could rise to that level depending on the nature of the relationship and whether a misleading information is being.
So I think, folks, that's about all the time we've got. I see a few other questions. I apologize to our audience members whose questions we didn't get to this week. But as always, we remind you that you're always welcome to call our offices at Cambridge LLP to get a legal opinion on your specific situation. That's my plug for the week. Otherwise, ladies and gentlemen, thank you very much for joining us this week. Quinn, thank you very much for being with us this week. And hopefully we'll see you all next week on Willpower Wednesday. Thanks very much. Cheers.
Thanks, Tim.